Hello viewers, welcome to our program on immigration and you. I am your immigration attorney Michael Fulwani, and once again we have with us attorney David Nachman. David, welcome.
Thank you, Michael. Thanks.
Now a lot of things to talk about in today's program, and as you recall, we have been talking to you about the dreamers. Dreamers are the people who were included in the DREAM Act, but the DREAM Act did not get through the Congress. So administratively, President Obama issued a memorandum to provide relief to those children who came to US under the age of 16 and who are not over 30 years old. But let me ask David to explain in a little more details, because we already done a couple of times. But to refresh again, let's talk about who qualifies, which children can.
Well, Michael, the individuals who qualify for these new provisions, which, by the way, the most important thing for us to realize is that there is no formal application process in place. So what we're doing is we're taking information from individuals who potentially can apply for these dreamer provisions, and it looks like we're going to have formal regulations, some type of, and they're not really regulations, but some type of formal policy in place by hopefully August 12th, August 15th. So what we've been doing is we've been meeting with people, taking their information, and basically showing documentation to prove that they meet the following criteria. So what are the criteria that you should be looking for? Number one, that the individual is 30 years of age or younger. Two, that they entered the United States before he or she was 16 years of age. Three, that they are physically present in the United States on June 15th, 2012, which is the date when the announcement was made, and that they continuously resided in the U.S. during the preceding 5 years before the announcement was made, and that they are currently in school or have graduated from high school or obtained a GED, which is an equivalency, a graduate equivalency, or honorably discharged from the Coast Guard or the Armed Forces. The individuals are not able to have any type of criminal conviction, felony, significant misdemeanor, or multiple misdemeanors, and that they do not pose a threat to national security. And as long as they meet those criteria, purportedly, they're going to be granted some form of status, which is deferred action. Well, yeah, and which is important, Michael, that it's not a form of status. It doesn't get the individual to the green card. It's really a form of status where the government has agreed not to take action and not to remove these individuals from the United States. So what this is really is a logical extension of the prosecutorial discretion memorandum that was passed last June by John Morton.
A couple of things let me add, that there is no path to citizenship or getting a green card under these, because that part comes from a law, and hopefully the Congress going forward may pass the DREAM Act, which may provide a green card for these dreamers and become citizenship. Right now this is a temporary program, and they get this status or permission to work only for a period of 2 years, and then every 2 years they keep on renewing, extending.
Right.
Now some people are very much worried also that this way we are illegal, but nobody knows about us, and we are going to the government, we are doing probably the biometrics, we are giving them all the information, where we live, who we are, how we came. Could this backfire in some way? And my thinking was that probably not, because that's not the whole purpose of this memo.
Exactly.
You have any comments to make on this?
Well, that's one of the big issues right now, Michael. The American Immigration Lawyers Association, which is the group of immigration lawyers across the country, and and I'm on the Board of Governors. What the Board of Governors has discussed is the possibility of having some kind of a confidentiality provision. And this confidentiality provision would give the ability of the government to not share that information across other databases. And you'll recall that this was a big issue that came out when we had the 245I program, that individuals thought, okay, well, what they're going to do is they're going to take this database and they're going to share this list of individuals who are not authorized to be in the United States. And that never happened.
Yeah, if you recall, 1986, when they passed that amnesty bill during President Reagan's time, it said in the law very clearly, the government cannot use this is confidential. They cannot use this information for any other purposes like arresting or deporting or anything.
Right.
And hopefully these regulations may provide that. Otherwise, a lot of people will be afraid what to do. The second, another concern is this, that hopefully President Obama will win the elections and probably this program will continue. But I'm a little bit worried, not too much. Supposing President Obama does not win, the Republicans win both the White House, Senate, and the Congress. It's possible they may revoke all these prosecutorial memorandums, and that may cause a problem.
That's right. It's definitely a possibility. And, I guess our clients and the viewers need to be mindful of the fact that something that comes can go just as quickly. However, what's kind of interesting is the timing here, and that is that if the formal methodology is implemented in August, between August and November, the process will have enough momentum, I feel, that it'll be very, very difficult to pull a process like that off track because a lot of people, their reliance will be induced between August and November. A lot of filings are going to go in, and then we'll have to see what happens. But that's going to be a tough pill to swallow.
Strategy. I don't think that there's a time limit that you must apply within 2 months or 3 months. Probably there'll be more time available when you can apply. So a smart guy may say, okay, let me wait for the elections. The first week of November, a couple of more months I'll wait to see what happens to the president, what happens to the Senate, what happens to the Congress. Then I'm more comfortable filing in after elections or in December.
Right. Well, and that is definitely a possibility. I just hope that there are not a lot of people who wait, because it's my hope that everybody applies quickly all at once, so that then the procedure is in place and the gears start to grind and the government starts to grant deferred action, because then they'll be faced with a very, very interesting question.
Correct.
If half of the people are granted and approved through the EADs, and then there are these other people, how are you going to treat similarly situated people differently? That would be considered discriminatory, and then that would give a whole bunch of other people the potential to file a lawsuit to be treated the same way. So personally, I would like to see all of those applications go in as quickly as possible so individuals get those employment authorization documents, so the process is moving forward. Michael, one of the other issues which has come up, which we need to talk about also, is something that's sort of an airball right now, and that is the ability of these individuals to travel. This is something which has been discussed. And it kind of is linked to whether or not they're going to treat this deferred action as a form of TPS, temporary protected status, which is a form of status that's granted now, where you make an application, you get an employment authorization document, and you get the ability to travel, or whether they're just going to give an EAD. And actually, our colleagues, many of whom have kicked this around at very, very high levels of AILA, the American Immigration Lawyers Association, we're trying to figure out, is this going to be done on a TPS form where they just add an additional condition on the TPS form, or is it going to be done on an I-765 employment authorization document where an additional provision is going to be...
the present card for 2 years, which says they can travel, they can work and all that. But my recollection, David, is, if I'm not wrong, I had a couple of deferred status cases in the past few years ago. And we were able to get advance parole from the Immigration Service. That means if the existing law, deferred status, provides a room, or not automatic, somebody has to apply and it's discretionary. If they extend that same provision more liberally to these cases as well, but in a way, because where is this coming from? Deferred status, deferred action, where is it coming from? It's already existing. It's not a new law. The Immigration Act provides that.
Well, the process exists right now.
Yes,
that's right.
The law permits that. So President Obama, what he's saying, something is already in the law. I'm just expanding to a different class of people. So whatever is there in the deferred status, work permit, staying legally, or maybe travel, we have to see how it goes. But it's a very interesting subject. I think we are watching very, very carefully. Both David and we are in touch with the concerned authorities, and we know on a day-to-day basis something happens, right away me and David know about
Absolutely. We've already met with dozens of dreamers. I've been taking documentation, as Michael has. We've been basically accumulating files and not formally opening them in our office, but basically getting all of the contact information and all of the documentation that we can to show these criteria for those individuals so that we're able to jump right in and make the applications when the formal provisions come down.
It's a very good idea. What we are doing really, David and me, our firm, is we are getting the information from dreamers who want to get this benefit. We want to know exactly, do they meet all these requirements? And then at least then we know there's an active case. If we feel the person is 17 or 18 when he came in, there's no point. And we tell them don't do it, because there's a little danger there. If people don't qualify because of any of the missing grounds or the criminal or crime of any type, which says serious crimes and felony,
Right.
then they are not only going to deny, but they may put that person in proceedings.
Well, Michael, it's very interesting. We had a meeting the other night with the CIS officers in the Newark district, and we had an informal discussion about the Dreamer provisions. And interestingly, the district director and many of the other administrative managers in the district office were saying that deferred action is a discretionary it's a discretionary status, and there's a tremendous amount of discretion that can be exercised in connection with this type of grant. So the question now is going to become, can they grant this discretion, and then at what level is it going to be adjudicated? Because the question becomes, are they adjudicating this at the regional service centers, where there's going to be maybe less ability to exercise discretion, or are they going to be doing it at the district level, where there might be more of an opportunity to exercise this type of discretion?
But talking about discretion still has to be in a judicious manner. For example, if a student meets all the requirements and the immigration says, I don't like the color of your shirt or the color of your shoes, for some reason.
Well, we call that abuse of discretion.
Yeah. They say, okay, that's okay, you do not deserve favorable discretion, so we're going to deny your application. I don't think that's going to happen. There has to be some basic reason, not meeting particular requirements, crime or something, that may, in their opinion, deny that application.
That's right.
Discretion is like that. It has to be, as I said, judiciously.
Correct. And Michael, I think what I'm saying is that we've received calls and in our office from individuals who may have missed it by a week, or we've missed, or we have individuals who possibly have some type of a criminal issue which doesn't necessarily fall within the rubric of what they're talking about here. So can they exercise discretion? Certainly, I think that they might be able to.
Yeah. Well, they should probably, not only able to,
I
I hope they do, and they would write. And we can talk a lot about it, but I think we are running out of the time. And as we get more and more information on this topic, we'll bring to you, to our viewers. Thank you very much, David, and thank you very much for watching the program.